The gender issue is contained and enshrined clearly in the Maputo Protocol under Article 2, under Article 9, which are the issues in contention in this case.
Which is the highest court in your land?
The Supreme Court.
You do not have any other court other than that?
Thank you for the question. The Supreme Court is the highest court established in the Constitution of Pakistan.
And therefore you feel that you've exhausted the local remedies in that?
Yes.
Proceed.
Through Article 9, we have the Maputo Protocol obligating state parties to ensure increased and effective participation of women at all levels of decision making.
We believe that when women are represented, we are going to bring about much change to the society.
We expect nothing but excellence from you, so I hope you will bring it.
The inaugural National Equality Moot Court competition took place on 4th of May 2017 at the Strathmore University.
I'd like to welcome you all to Strathmore University, and more specifically, the law school. I'd like to welcome the students, the judges, the participants, and our guests. We are particularly honored to host the inaugural National Equality Moot competition on the Maputo Protocol on the topical issue of the implementation of the 2/3 gender rule in elective and appointive positions.
This gives the students an opportunity to engage in current affairs, especially that Kenya is now undergoing elections, and the gender equality rule is very critical.
Team A, Team B. So Team A and B will be the first in panel 1, Team C, Team D, so Team C and D will be the second session in panel 1, and then we'll go on like that in accordance with the program.
The first objective was basically advocacy.
A just society is gauged by the way it treats the marginalized, the vulnerable, and the less fortunate, as well as the disadvantaged members of the society.
To increase knowledge and appreciation of the protocol to the African Charter on the Right of Women in Africa, also known as the Maputo Protocol, to upcoming lawyers in our law schools.
In the African Court on Human and People's Rights, in the matter between the Federation of Women Lawyers of Bannister and the Republic of Bannister.
The court is now in session, and we're now proceeding to hear submissions from both the applicants team and the respondents team.
To achieve this, we invited all the law schools in the country to undertake preliminary selection in their schools with the aim of introducing as many law students as possible to the Maputo Protocol.
When I refer this court to the Maputo Protocol, Article 2 and 9, the court protocol requires Parliament and state bodies to combat all forms of discrimination, to ensure they do, to move heaven and earth, to make sure that they curb discrimination in their states.
Firstly, we shall argue that the gender rule is amenable to immediate realization and not progressive realization, as the respondents may argue. Secondly, we shall also submit that failure of the respondent state to take legislative measures to give effect to the gender rule amounts to a contravention of the obligation, both under the Maputo Protocol and under the Convention on Elimination of Discrimination Against Women, to ensure that women participate in the public life and the public discourse of their country.
Your Excellencies, it is pertinent for this Honorable Court to understand the meaning of the term discrimination against women before we proceed. As per Article 1 of the Maputo Protocol, which is the same definition rendered in Article 1 of the Convention on the Elimination of Discrimination Against Women, discrimination against women is described as any form of distinction, exclusion, or differential treatment rendered upon women that upon affecting the manner in which they may enjoy their fundamental freedoms and human rights. Your Excellencies, Article 2 of the Maputo Protocol goes a step further, and this is an obligation in all the member states to eliminate any form of discrimination against women through any form of means such as institutional measures or legal measures.
The participating law schools were University of Nairobi Law School, Moi University Law School, Kenyatta University Law School, JKUAT University Law School, Strathmore University Law School, Kabarak University Law School, Riara University Law School, Catholic University Law School, Kisii University Law School, and Mount Kenya University Law School. The objectives were met as reflected in the passionate argument that were made by students during the Moot competition.
Yes, we subscribe to the doctrine of democracy, but really, is this democracy? Is democracy and representation of the people being implemented in our country? If it is, why aren't we being appointed in these in state bodies? Why aren't we being represented in state bodies?
Your Excellencies, Article 2 and 9.1 of Maputo Protocol and further Article 3 of the International Covenant on Civil and Political Rights obligate state parties to enact, to contain in their national constitutions and also legislative measures the principle of gender equality. Your Excellencies, we wish to draw the court's attention to the various legislations that has been enacted by the state of Banista with regards to implementing this rule, Your Excellencies.
In the same manner that we have the other legislations, including the budget and other pertinent issues being passed in Parliament, the same format should be followed in ensuring that women representation is legislated. I would give an example of the neighboring country of Kenya. When an important bill needs to be passed in Parliament, the President himself calls what the Kenyans call a kamukunji of friendly and like-minded parliamentarians, and buttresses the point that this issue has to be passed.
The second objective was to create a dialogue on the way forward in the implementation of two-thirds gender principle in the context of a reluctant parliament that has failed to pass the necessary legislation to give effect to the gender principle.
Has Parliament done this? It is our submission as the applicants that Parliament has failed to adhere to the Maputo Protocol and the in Article 2.9. This is because Parliament should have at least educated the mass on the importance of equality, on the importance of women representation. In paragraph 12, women fail to be represented because of social, economical, and beliefs and attitudes that the African people have, that we African people have about women representation. Parliament should take action to ensure they educate the mass, show the mass the importance of representation of women.
Your Excellency, under our merits, we submit that the failure of the government to give effect to the gender rule in terms of legislative measures, and we shall argue this in a twofold manner. Firstly, we shall argue that the gender rule is amenable to immediate realization and not progressive realization, as the respondents may argue. Secondly, we shall also submit that failure of the respondent state to take legislative measures to give effect to the gender rule amounts to a contravention of the obligation, both under the Maputo Protocol and under the Convention on Elimination of Discrimination Against Women, to ensure that women participate in the public life and the public discourse of their country.
On the third and the fourth issue, the third issue being whether Parliament has failed in enacting legislation for the implementation of the two-thirds gender rule in elective positions, and the fourth issue being whether the executive has failed in ensuring implementation of the two-thirds gender rule in appointive positions. Your Excellencies, it is our submission that the state of Banista, the Parliament of the state of Banista, has violated Article 2 and 9 of Maputo Protocol, Article 2 of ICCPR, and Article 8.2 of the African Charter on Democracy, Elections and Good Governance, Your Excellencies.
The students, the judges and the guest speakers were all focused on finding a way forward.
Therefore, I'm going to invite the first speaker to make the presentation. Please proceed.
I understood Council to be saying that Article 261 of the Constitution provides an effective remedy. Is Article 261(5) really about effective remedy when we talk about gender representation or parity, or is it just a whip or punishment to Parliament when it fails to enact the law?
It's the respondents' submissions that Article 261 actually presents a remedial remedy in the case that the legislature fails to give implementive measures or fails to take legislative steps to give effect to the gender rule. And this might be seen as a whip. However, this we submit would be a positive step on the part of the state to show its commitment to actually pushing the woman agenda. because under Article 261(5), if the High Court gives additional timelines for the legislature to take legislative measures and it contravenes it, then there are other repercussions that may arise. And these repercussions are that of declaring Parliament unconstitutional.
Taking into consideration the mischief that the two-thirds gender rule sought to address, the social, cultural, economic, and political context within which this case has arisen in the state of Afghanistan, the role of Afghanistan as a state in the promotion, protection, and furtherance of women's rights, and the coming general election in the state of Afghanistan. How does your response to this application help, one, in the furtherance, protection, and promotion of the rights of women in the state of Afghanistan? And two, how does your response to this application assist this court in the development of African jurisprudence in the protection of women's rights? Thank you.
Your Excellencies, indeed our submissions that our application before this court would actually have good jurisprudence for this court, particularly because, and particularly with regards to the issue of exhaustion of local remedies. We have submitted that there is still an avenue in the domestic courts of Afghanistan which can be exhausted. And so this court actually agreed with our submissions would actually go forth to show that this court indeed should be a court of last resort rather than a court of first instance. And if there is actually a possibility for exhaustion of local remedies, it has to be taken. And we make reference to the case of Inaugural Justice Council versus Ethiopia, a decision of 2006 in which at paragraph 58, the African Commission held that even if there is the slightest possibility of a remedy being effective, that remedy needs to be pursued. Thus, the applicants will have to pursue these remedies or show the court how exhaustion of these local remedies have been unduly prolonged for them to actually bypass that and seek recourse to this court.
My question is with regard to your interpretation of the state obligation insofar as the implementation of this principle is concerned. The language in your own constitution, the language in the Moot Protocol, the language in CEDAW is very deliberate. It says shall. So how do you interpret your obligation insofar as the language of the framers of those documents is concerned, in that they impose a positive obligation? So in essence, I would like you to expound on how the state of Afghanistan is complying with this due diligence principle insofar as this obligation is concerned. It seems from your arguments that there's been a lot of abdication of the responsibility. So if you can just expound on that.
On the issue of the use of the language shall that has been raised by Your Excellency, indeed, it's our submission that the use of the word shall is not cast in stone. And first we make the submission that the issue about the gender rule was not a specific legal right, but was actually a constitutional principle. A constitutional principle that will only concretize into a specific right if additional remedies have been, if additional steps have been taken. And these additional steps are legislative, policy, and administrative, all of which are long-winded and protracted and require time. For instance, this has already been implemented at Article 177, 1B of the Constitution that provides for modalities of the application of the gender rule.
With international litigation in the African Court on Human and People Rights in Arusha, using the Moot Protocol being key strategy under the analysis.
The work done towards achieving gender equality is so important in ensuring social justice and justice for the entire society.
At Equality Now, our agenda is women, our agenda is human rights, and that is why we've thought it fit to actually approach partners such as the Strathmore Law School and Safaricom and others to just make this conversation transcend beyond our four walls in the office and just be a conversation that brings together many more parties who are not necessarily doing this work that we do every day.
So at Safaricom, we're very excited to have partnered with Equality Now at Strathmore Law School to support the inaugural National Equality Moot competition. Some of you may wonder what business a communications company like ours has in supporting a moot court competition about equality and also about gender equality. So the way we think about ourselves is Safaricom is a young company. And we want to grow to be 100 years, and we want to grow to be those 100 years gracefully. And to do this, we know we have to operate in a just and equal environment, and as a company, we must do our part to achieve that.
Fortunately, we have had eminent women lawyers that have led to the women's movement. The women's movement has engaged in an elaborate, widespread, and comprehensive advocacy for gender equality and women's rights, using tools such as advocacy, education, and agitation for legal reforms. These efforts must be recognized and carried by all of us. Christina Hooker, a professional leadership consultant, coach, and trainer, has identified leadership traits which she proposes are unique to women and which front the case for women to be placed, albeit strategically in leadership positions. At the national level, National Assembly has listed women, which translates to about 19.4% of the total membership. While at the Senate, courtesy of nomination again, we have 18 women out of 67 senators. In total, we have therefore about 26.9%, the lowest percentage of women in East Africa in terms of women in politics.
The lessons learned were participation in national dialogue on issues of governance and the realization of fundamental rights must be inclusive, especially of the younger generation of Kenya, who have a potential to come up with innovative solutions that may help the country move forward. It was clear from the dialogue during the Moot competition that young people have innovative solutions to the nation's problems and must be included in decision-making on all issues of importance to the nation, for they are the leaders of tomorrow.